Hey guys, welcome back to my channel. What's going on, guys? I am trying to get this darn thumbnail straightened out and in order. I was just live over on Love Lies and Lace Fronts. If you're following me over there, then you already know. You already know what's going on here. So, sis is just trying to handle that business. Okay. Give me just a second. Let me handle this thumbnail business. And girl, let me handle this thumbnail business. Anyway, how is everybody doing? What are you guys eating for lunch? And Miss Portia, please, girl. Miss Portia. Miss Portia. Miss Portia, please. Y'all. Okay. Jesus. Okay, I hope everyone's doing well. And we're going to get into some business real quick. I was handling mom business last week and I missed the Daryl Brooks hearing. Did you guys see the Daryl Brooks hearing? Did you guys see Daryl Brooks is trying to represent himself in his appeal? Did you guys see that? I would like to take a look at that today. Also, I did see some news that Kimani's grandmother and mother were over there at the probate court. Girl acting up. They are trying to, if you've been wondering why young Keimani Latig has not been laid to rest, I got an answer for you. Okay. There was a battle between the mother and the grandmother regarding her remains and what would happen. The mother, who relinquished her rights, was concerned that she was not going to be invited to the funeral. This is like real life stuff. You know what I mean? This isn't just like a nuance to this particular situation. I see y'all coming in. I see y'all coming in here. This is not, you're eating some salmon and corn. Okay. Yum. This is not a nuance only to young Kimani, but unfortunately this is the reason why there's probate courts. There's things that are just not settled. And after she was declared dead on March 25th, the Lucas County Coroner's Office performed the autopsy of the body of 13-year-old Kimani Latig and found the cause and death. There were multiple incised wounds of the neck. The manner of death is ruled homicide. Kimani Latig was pronounced dead at 1100 block of Miami Street, Toledo, Ohio on 3/24 at 12:19 p.m. And that was the deputy coroner, Carl Schmidt. But yes, on yesterday there was a hearing. I wish I had access to this hearing. Mom was on Zoom. Let's see. There's some, but you never know. I mean, they may give us, you never know what may be posted later, because it seems like Ohio is pretty good about posting some things, but there was enough. So we're gonna take a look at that in a minute. Check out Daryl Brooks in a minute. I'm trying to think of what the Nesto stuff that I wanted to cover with you guys. We have a long list of things to get caught up on. We were over there at the Lori Vallow. I wanted to see the opening statements. I wanted to see what Lori was doing. Monday was kind of interesting. Yesterday, baby, I was exhausted from being exhausted of waiting. It was lots of waiting yesterday. So it kind of made it a little, I don't want to say it made it less interesting. I just kind of was like, I got other stuff I want to report on, and I'll continue to watch, and maybe we'll do some updates as things heat up. But right now it wasn't, you know what I'm saying? Like, it just, for me, it was time to, I'd seen what I came for. I'm going to put it like that because I want to keep it very cute. I said I'd seen what I came for. And as the trial heats up, if there is additional heat, then we will circle back. But right now, while it was not giving and it's very much like, huh, what? Okay, we're good. Um, we'll circle back. Okay, we'll circle back. We did 2 days. When the family, when Charles Vallow's sister comes to the seat, when some people, I want to hear more of the story rather than all of the technicalities with the police. And I'm sure they're probably going to do forensics. I don't know what they're doing today, but baby, I'm not going to be there for it. When they sit with the family and they start to tell the story, then I'll be more inclined. Um, Girl, who is this? Hold on just a second. Let's see what's going on here. Oh, okay. All right. Let's listening during my planning period. Okay. Shouts out to all the teachers. I know what that means, teacher. Okay. Let's get into it, guys. Here is Annette. Am I saying Annette? Dorothy. Girl. Dorothy Latigue. I don't know why I always want girl, I know why I want to call her Annette, but I'm not. I need to okay, Dorothy Latigue. Kimani Latigue's grandmother was in court yesterday and she was over in the probate court. And if you were wondering why Keimani has not been laid to rest, this will answer your question. She has not been laid to rest because there have been some drama with her final arrangements. Number one, there was some drama with the funeral home. The first funeral home that they had set up, sir had some sort of creepy yoki, some sort of um past. I'm gonna say it like that. Um the initial funeral home for Kimani's funeral, the funeral home director had a sordid or questionable past, and people were outraged, and he passed it on to another funeral home. Okay. So that was one thing. There have been public monies collected and she will be laid to rest properly. But the grandmother, Miss Dorothy Latigue, Dorothy has gotten approval from the judge. The judge grants Keimani Latigue's grandmother the right to handle the funeral arrangements. Let me see if it's ready or is there a commercial gonna pop? Girl, we don't want to watch it. Um, so that's what was settled at the hearing, and I'll let you guys let's get into it. Just a second. Let's
Burger made it clear why Kimani's mother and
okay, let's see right here. Let's see.
Burger made it clear why Kimani's mother and grandma
Why can't I get that from the very beginning?
Shaq Puffenberger made it clear why Kimani's mother and grandmother were in court. Kimani's mother, Tiara Caston, appeared virtually.
There seems to be some disagreement between next of kin on how the disposition of the deceased remains.
So there seems to be some disagreement between the next of kin and the decedent's remains. Okay, that's what he's here to settle at the probate. Okay.
To clear why Kimani's mother and grandmother were in court. Kimani's mother, Tiara Caston, appeared virtually.
There seems to be some disagreement between next of kin on how the disposition of the deceased remains.
Her grand
So Kimani Royale Caprice Latigue, that's her name. This document right here, probate court. So they filed a complaint in the probate court. Application for right of disposition. Okay.
grandmother, Dorothy Latigue, filed this paperwork in probate court on Friday, asking the judge to hear the case. The grandmother said her only desire is to dispose of Keimani's remains respectfully, but they can't bury the child because she and her mother are fighting over who has the right to plan the funeral.
To my understanding, we had a disagreement only because she felt like she wasn't invited to the ceremony, only because we have not kept in contact since the situation arose.
Police say
Are there invitations to I mean, I guess people do get notified, but I don't know.
Felt like she wasn't invited to the ceremony.
Fighting over who has the right to plan the funeral.
To my understanding, we had a disagreement only because she felt like she wasn't invited to the ceremony, only because we have not kept in contact since the situation arose.
Police say Kimani Latig was murdered at the hands of her father, Darnell Jones. Her body found in this abandoned home. The community outraged. Her body moved from funeral home to funeral home. Judge Puffenberger saying this has gone on too long. He based his decision off of how close the women were to Kimani and their plans for the funeral.
She's not just been in my house for the past 5.5 years. When she was with the prior custodian, we still kept contact to the point where Kimani was still coming back and forth to my home.
Kimani's mother told the court,
"The last time that I was permitted to see my child was her 11th birthday."
Wait a second. So the last time she was permitted to see her child was her 11th birthday. Was she not all over social media talking about she had just seen Keimani like a few days before she had passed away? And she was at her house or something, and Darnell came to pick or something. Wasn't there some sort of situation like that? Well, I guess those are the legal terms of how you're handling someone's remains. Yeah. I don't think dispose, I don't think they mean as in that way. I think it's just the final disposition of the person's remains. I guess that's just the technical legal way. I'm assuming. But back to, so the last time, I just feel like the mother had said something else about her last time seeing Kimani, and that there was a day they were like, they were scoring on each other, they were playing, they were having fun. I don't know if she meant that was like supposed to be on FaceTime or something like that. But baby, if the last time you saw her was she was 11, last time you were permitted, and she was getting ready to be 14, hun, that's a long time. That's 3 years for a child. That's a quarter. You know what I mean? That's going up on a long time.
I would say that based off of the interactions that I've had with my daughter and the conversations that we had, I do believe we were close.
Ms. Latig, I assume your daughter would be invited to the private family funeral.
And of course,
You would not try to exclude her.
no.
he asked how the grandmother would pay for the funeral.
Was there some community money donated for a funeral?
There were several organizations that are providing their services. So to date, again, everything is paid for.
The judge ruled in the grandmother's favor.
What I had planned was a private ceremony so that the family could attend, and we have a open casket funeral, and then there was a public ceremony also planned for the community.
And Kimani's grandmother told the judge that she would like to have Kimani's funeral this week. Back to you.
So I guess her private family funeral, but they also gave, let's see what it says in the article. I think she was given permission to cremate. Lucas County judge determined Tuesday that the grandmother of Keimani Latig has the right to handle funeral arrangements. Judge Jack Puffenberger determined Dorothy Latigue had the legal right to plan the funeral for her granddaughter. You don't see your daughter for 3 years. I hate it for the lady, Tiara Caston, but ma'am, We don't plan the day and time nor the hour. We don't know when things are going to happen. And baby, you were absent for too long, unfortunately, and you missed that right. It's sad, but this is going to be a lesson learned for a lot of people. If you're absent from your kid's life, you can't come in at the tail end thinking that they're going to roll out the red carpet for you to all of a sudden assume your role, and be able to do things that, I guess, the when the judge looks at it, you don't get that right. It's unfortunate, but and Dorothy ain't no better. Let's just be honest. Okay? Wasn't there some lie like that? She said the dad bought her over and she gave her, so the man who ends up taking her out of this world brings her to the woman's house where she's not permitted to see. She gave her $100 for her birthday and gave the dad $60 for food and gas. I remember that they were saying something like that. This was a whole mess. Rest God rest little Keimani's soul. Dorothy Latigue said she plans to invite Keimani's mother, Tierra Caston, to the services. Detail for those services are unverified at this time, but the judge determined that there will be a public and private service. It is likely to be held this week. A spokesperson for the funeral home said they will let the news media know specifics when it's finalized. Dorothy filed the paperwork in probate court last week, asking the judge to hear the case. She said her only desire is to dispose of Keimani's remains respectfully. I think that's the legal term, dispose. So like carry out. There's so I think that's just the legal terminology of handling someone's remains. They haven't been able to bury Keimani because Dorothy and Tierra are fighting over who has the right to plan the funeral. To my understanding, we had a disagreement only because she felt she wasn't invited to the ceremony. We had a disagreement because she felt like she wasn't invited to the ceremony, only because we have not kept in contact since the situation arose, Dorothy Latigue said. The community has been outraged as the teen's body has been moved from funeral home to funeral home. Judge Puffenberger said the case has gone on too long. He based his decision off of how close the women were to Keimani, along with their plans for the funeral. She has not been in the house for the past 5.5 years. When she was with the prior custodian, we still kept in contact to the point where Keimani was still coming back and forth to my home, Dorothy Latigue said. Tierra Caston told the court the last time she was permitted to see Keimani was on her 11th birthday. Sis, that was 3 years ago, okay? I would say, based on the interaction I had with my daughter and conversations we had, I do believe we were close. Judge Puffenberger asked if there was community money donated for a funeral, and were several organizations that were providing their services. So to date, again, everything is paid for, Dorothy Latigue said. What I had planned was a private ceremony so the family could attend and we could have a open casket funeral. And then there was a public ceremony also planned for the community. Channel 13 Action News reported last month Brown Legacy Memorial Funeral Home was originally planned to hold a public and private for Keimani, but was later transferred to Dale Riggs Funeral Home. Yeah, Brown Legacy had an issue. I think that man had some sort of background that was not conducive to children, and it was immediately changed to Dale Riggs. Investigators found the 7th grader's body just over 2 weeks ago at an abandoned house on Miami Street. The teen's father, Darnell Jones, is accused of abducting and killing her. Okay. Dorothy Latigue appears in the Lucas County courtroom with her daughter, Tiara Caston, appears virtually via Zoom as the judge determines who will have the rights over the funeral for Kimani Latig. And the decision was made by the judge that it would be the grandmother. The Blade newspaper said Lucas County probate judge Jack Puffenberger has granted Keimani Latigue's custodial grandmother's application to handle the girl's funeral arrangements, including cremation of her body. After a hearing at which the girl's mother, Tiara Caston, participated by Zoom, the judge on Tuesday granted without comment Dorothy Latigue's application dated Friday for the right of disposition according to the court's documents. I would like to properly hold a funeral and cremate her remains without it becoming a circus for the family, the grandmother wrote in an application. While not involved in her daughter's life for approximately 2 through 5 years, Mrs. Latigue wrote, Ms. Caston now was claiming Kimani's body and making a spectacle out of this tragic situation. Judge Puffenberger said later Tuesday that the case was a first for him. While cases occasionally arise in which someone wishes to disinter a body and bury it somewhere else, he said, I don't recall having one before regarding the right to bury someone before they've been buried the first time. Baby. In the comments. Okay. Okay. I think he is still in custody. I've been searching. Let me just do a search real quick just to see. Cuz I'm like, well, damn. He's been in the hospital for damn 2 weeks. Columbus. Darnell Jones release. Oh, girl, 9 minutes ago. Darnell, man accused in custody of Columbus Area Correction Center. Okay. Okay, hold on a second. Baby. Uh-oh. Okay. This was 9 minutes ago, okay? Darnell Jones, a man accused of killing his daughter, Kimani Latig, last month, is in custody at a Columbus area correction center. He was previously hospitalized after a Columbus police officer shot him more than 2 weeks ago. According to Franklin County Sheriff's Office, Jones, who also goes by the surname Ogletree, is in custody at the James A. Carnes Correctional Center as of Wednesday. Jones' arraignment in Columbus is scheduled for 9 a.m. Thursday. Jones is charged with felonious assault in Columbus and is charged with murder, felonious assault, and abduction in her death. Until Wednesday, Jones had not appeared in any official court or jail documentation. There is no word yet on when he'll be extradited to Toledo. Jones is pictured below in a 2022 mugshot. A current mugshot has not been immediately available by Franklin County Sheriff's Department. Let's go. Keimani Latigue's disappearance and death. This comes, just a second. Let me get my arrow together. This comes more than 2 weeks after Keimani's body was found in a blighted East Toledo home on March 24th. Following a week-long disappearance, Jones was charged with murder in Keimani's death. According to Lucas County Coroner's Office, Keimani's cause of death was multiple cuts to the neck. The manner of death was ruled a homicide. Jones has been charged with murder, felonious assault in her death. Columbus police SWAT officers shot and injured Jones last month and apprehended him. Since then, he has remained in Columbus. Jones was the last person to see Kimani alive before she was reported missing on March 18th, according to the police. Jones was accused of removing her from her home without her guardian's consent and giving police inconsistent statements about his activity with the victim, according to a warrant issued for his arrest. Okay. Okay. It's been, geez, uh, okay, hold on just a second. Let's see. I guess they're, is this it? Just a second, guys. Okay, that's not, ooh, ooh. And then I clicked out of it by mistake. My bad. Um, I'll find it. Um, yes. Hold on, let me see if I can find it again. Columbus, Ohio update. Darnell Jones. Okay, this was the one. Let me see. Does this have video with it? It just like started playing. It seems like there's some sort of a video update, but I can't seem to. Okay, but we read the whole thing. I think it's we'll look for more before we sign off of here. I'll see if I can find some information based on where they said his location is and see if we can get any information. Also, if I can pull something from the probate court, some documentation from the probate as far as what did Dorothy file. She filed some sort of like affidavit stating that Tierra Caston was trying to make it a circus and she was not, and they brought it to the probate court to settle. I don't know. I think unfortunately Kimani didn't have the best situation going on with the adults that were adulting over her. I don't think that she had the best situation, unfortunately. So I think the judge probably went with whatever he thought was the best thing at the time. Because this is what you have to do. I mean, get the baby buried respectfully, lay her to rest, and you guys can go ahead and go on with your shenanigans. So I guess that's the task at hand. So let's see if Grandma Dorothy can handle that, because there's court orders involved. And I think that now is the time to handle business appropriately. So let's see if she can do it. If she can't do it, it's going to be a problem. Okay. This was interesting. I was watching this morning. You guys are familiar with the Daryl Brooks case. Daryl Brooks is pro se, and Daryl Brooks he has a lawyer, and they have put in for his appeal. I don't know what his defense is or what his premise for his appeal is, but baby, he's put in for his appeal and he's trying to get his appeal underway. This is his lawyer in the bottom right hand corner, and he is hoping that he will be able to maybe get some relief off of some of these life sentences he has. I think he's got 6 life sentences, if I'm not mistaken. Let me see if they have 6 people. Yes, he's got 6 life sentences. This was interesting because he's supposed to be like at an undisclosed location, but it came out exactly where he is in this particular hearing, which I felt was very interesting also. So let's listen to this, and then I'm going to see if I can find some more information about the probate court documents, and also see if I can find some information about Darnell in the Columbus Correction Center while we're watching this. Okay. And while you're coming in, go ahead and make sure to tap, tap, tap on the like button for me. I so appreciate it. Let's get into it. This is Daryl Brooks' hearing. This actually happened on the 4th. Where was I on the 4th? I think that was Friday. I was coming back from my trip. So we're just now getting to it. I have like a list of stuff I want to get through with you guys. But yes, this happened on Friday and it was pretty interesting. So let's get into it. Okay. Let me see what you guys are saying. Uh-oh. Girl, he has a lawyer. He wants to fire his lawyer, actually. He wants to fire his lawyer, Leah. Yes. Girl, he wants to fire. So basically, the judge is being super duper careful and walking him through what that means if you let your attorney go and what's that going to look like. So based on that, that's where we're at. Okay, let's get into it. Do I have it on the right speed? Yes, it's on normal. Okay.
Is live streaming through the daycast function. Are you able to also see your attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Thank you so much. And any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes.
As everyone is aware, the court is live streaming through the daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin. And we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Covey, that would suggest otherwise?
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Were you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with them personally, though.
All right, I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge. I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain.
You may.
The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the 2 groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal as to whether or not they were viable post-conviction or appellate issues. I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a 2-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client. So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately, when discussing with Mr. Brooks, is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certainty. And multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency?
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's such it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. Also, I'm in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I have solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Kei'Mani Latigue'S for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you?
Absolutely. I have the highest level of certifications the public defender's office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a
I just
post-conviction
dropped the
motion?
membership link.
Judge, let me just say this again. I've certainly had lots of conversations.
Thanks for
with Mr.
asking.
I mean, I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations.
Thank you. You get
because it
me. I
was my
appreciate
intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy.
So I did find another update, and it might have a little bit more of the probate session if you guys want to watch that when this is over. This isn't too long, but her and the judge and Daryl get into it more in a minute. So this is the part towards the it'll start in about 4 or 5 minutes where it's just like, sir. Okay.
Copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple banker's boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive.
If we sent them disk and flash drives,
Look at
very
Daryl.
confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer?
You guys are so funny. It's like I can't even help but interrupt. I'm trying to not, but yet it looks like they put him into like a storage room. He's like where the office supplies or like the office snacks. He looks like he's in where the Amazon shipments, office snacks, office supplies. He's in like the maintenance closet.
And as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program Facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence, there would have been a mechanism for me to do so.
Do you imagine being on that Zoom?
In Wisconsin, if
I feel like we're
hypothetically,
on the Zoom now, actually.
if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
So this isn't old. This is, well, it depends on, some people think something from yesterday is old. So you got to define old. This happened on Friday. Okay. So maybe y'all just came in. For whoever just came in, this happened on Friday. Okay. So it depends on what you think is old. It's like tomato. Some people think 2 minutes ago was old, but this happened on Friday. He's filing for an appeal.
That
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow
No worries. It's just like I said, this internet, baby. Like I said, yesterday is old. I put up a video one day. We were talking about something that happened like 2 or 3 days ago. And I guess because 25 other bloggers talked about it, baby, someone came in here and was talking about that's old. It's like, so you know what I'm saying? Like I grow, it's relative. But yes, this actually happened on Friday. He's applying for an appeal. He's now, I think, in South Dakota, and he is relieving his lawyer. He wants to go pro se because I don't know why he's not going to say, he's going to start talking in a minute. But so they're having what they called a colloquy, and basically they're making the full determination before she approves for him to go pro se and for him to get a firm understanding that the appeals process is different from his initial trial, and to make sure that he is ready for the undertaking if he's serious about this appeal. So yeah, this happened on Friday, boo. Mm-hmm.
Along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure, should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm
Are you talking about the, I saw that?
Frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate
It's like
Office.
he's
Is that ringing a bell
legendary.
at all?
I apologize. I didn't realize my mic was still on. So I know you guys are hearing Portia whining in the background. Let me go back on mute. But yeah, he's he's legendary at this point, right?
I think from previous letters in my year.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks' directed attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw.
Yes.
Do you have any questions for me about that?
No.
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Yeah.
Do you have any questions for me regarding that?
No.
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294.
Did he roll his eyes? I mean, sir, you've got 6 life sentences. I don't know if he thinks he's going to get these overturned or not. I did see someone say he's wasting taxpayer money. I mean, it's a mess. But then the judge is doing her job. You know, don't you hate when you're just trying to do your job and somebody's being a complete ass?
4, also found at 259 Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal.
Hey, excuse me. I need to come in and get some pencils. Are you okay in here in the supply cabinet room?
And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Covey to withdraw?
Yes,
Did he send you a copy of the motion to withdraw?
yes,
Have you reviewed it?
yes,
Do you have any questions about it?
no,
Do you take any issue or claim made by Attorney Covey in dispute?
no,
Did you at any point in time tell Attorney Covey you're fired?
no.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks would ask me, when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great, thank you. I appreciate that clarification. I still wanted to ask from
Sure.
his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Covey to withdraw?
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You could definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying. Yeah.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights.
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Yeah, I do understand that. I kind of anticipate that with where I'm housed. Is like I said, it's a lot different.
I would say, look, you're not even in the state. You don't have access to our books. You may not have access to a satisfactory lot. Like we know, you know what I'm saying? Like, not to say between the states, there's not adequate research material, but if the judge knows what's available in their state, I don't know. To me, I'd be like, sir, you just have a seat and deal with your lawyer. Like, there's no reason if you're really serious about appealing, not that you're getting out, but at the end of the day, if we're trying to give you a fair shake at an appeal, you're at a complete and total disadvantage. And then it kind of takes up time for people who actually have real appeals, that they're wasting time with you fooling around on the docket. You know what I'm saying? You need a whole professional to move this along, whether it's going to go somewhere or not. We don't need you like malingering through the system. You know what I mean? Like, that's just extra work for a lot of people, especially if he doesn't have the tools and resources. And sir, at the end of the day, you got 6 life sentences. Like, damn.
Um, things are done totally different here. So I'm
I
aware
think
that
she can't deny it. I think she could just say, based on what you're saying, my first thing would be like, look, based on the strength of last time you defended yourself, you got 6 life sentences right there. I'm going to just deny. But on top of that, they sent you out of state, and I don't know what you have access to there, and you can't even get all your records. Okay. You can't get all your records. And last time you chose to defend yourself, sir, you lost 6 times. 6 times in a row. You have no hopes over here. And go back to number 1. You know what I'm saying?
that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say.
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief.
The judge is getting ready to say, I'm not keeping y'all secrets, okay?
Segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
And she said, period
Mr.
on
Brooks,
that.
do you believe that despite some
don't
of the
play with her.
challenges that you described, or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
He's got his hand over his mouth like Sonya. Like, I don't understand why people who have messed up teeth try to put their hand over their mouth like they're really hiding something. Like, that is not normal to cover your mouth like that. So we know something's up. It's not like you're covering something. If your mouth is jacked up, baby, just go ahead and roll with it, because we know something's wrong because you got your hand over your face. Nobody walks around like that. That's too much energy.
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? You understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody, further complicated by the fact that you're serving those out of state, and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Colby was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options. And that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that? You want me to?
He's a
restate that?
troll.
No, I said yes.
No, you
Oh, I'm
didn't.
sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's, in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes. And to be clear, there was no disputes between me and Attorney Colby. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right, do you have any medical issues that would interfere with your ability to understand?
Why does it look
what's
like he's
going on?
sucking his thumb?
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template. And I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is, from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not.
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Um, just understanding should be there that, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record. That it's just a lot different, and there's a lot of different procedure wise things here. So I'm still navigating that as I haven't been here that long. So I'm still learning as I go.
So that being said, why would you think, as not an attorney, that you would be the best candidate to navigate the appeal waters when you have not one, not two, not three, not four, not five, but 6 life sentences? What makes you think that you're the best person to handle all of this when you're now out of state? That's just ridiculous.
So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Colby, anything you think? I've
Well,
overlooked
she's
here
told
today
you
as
10
relates to this motion?
times.
Judge, I'm very
She's
sad.
told you 10 times that if you decide that that's not what you want, you're going to have to pay for a lawyer. They said you're indigent, so you probably don't have the coin for that, sir. And I don't know that you have the backing of people who support you to pay for something like that. Okay? He's ridiculous. I think he just needs books. He needs something to do. They need to give him a job or send him to school in the jail and give him something to do in the prison, because he clearly is not busy enough to be bothering people, to be taking up the judge's time with this mess.
Satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole uh, flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
I mean, they can't explain it to you. You're talking to the court, and you're talking about a prison matter. The prison doesn't, and the judge doesn't have any say over what's going on at the court, at the jail, at the prison in another state. They don't have any say over that. The prison runs how it runs. She can make sure, she can order that you have certain things, but if it doesn't align with the prison and how they do business, like for instance, maybe some prisoners have access to computers and they have a full library and all of those things, you're not going to have Wisconsin law books, books specific to Wisconsin. You're going to need to use a computer. They might not have a computer for you there to use. So you're going to have South Dakota law books. You know what I mean? Like, he's just ridiculous.
Attorney Covey, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and extension notes and templates, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just gonna say that too.
So he's a court appointed lawyer. So he's going to get the money through the fund. So he's not going to do this for Daryl for free. Basically to scan the documents and get him all of his files, he'll hire the paralegals. He was saying that he would fill out the paperwork through the public defender's office to pay for him getting his final paperwork. So I guess that's probably something he has a right to. So, yeah, he was saying that earlier. He was going to hire some clerks or paralegals to be able to scan through his boxes, just like Sarah Boone, just to get, not the similar. It's not as it pertains to an appeal with Sarah at that time, but as it pertains to somebody needing to have all of his items so that he can handle his pro se business, they're going to scan everything. So, but then, okay, you get a bunch of jump drives, but where's the computer you're going to use? You know what I mean? Who's providing you a computer and monitoring your usage? Like, he's a whole problem. We don't even know. I think the judge, part of her due diligence would be to verify that the prison would be able to support him, because all of a sudden you get in the mail 5 jump drives and that has all of your information for your appeal. How do you use the jump drives if you don't have a computer? Like, he's creating, the judge should just say no. Hopefully she says no.
There's no law library, which I've never seen a jail or a prison without a law library. So,
well, Nestor doesn't have access to, I think Cobb County does have a law library, but the Fulton County inmates aren't allowed to use.
I don't know how that's gonna work.
Do you have access to anything through a computer or online to access research material?
I have access to look at I believe it's Westlaw, and those are tablet based. But even that is
I would say motion denied.
challenging.
I use a tablet-based Lexis. It's a similar platform. It can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at. But
Sure.
I think it's similar to what you had when you were in Waukesha, is that not?
Anyone in the chat been to jail? Hey, anyone in the chat been to jail? Wanna pipe up? I would say if you were over in a couple of, you know what I'm saying? Like, I don't know. I'm going to speak for me. I'm going to say no. This might not be the chat for that question. Hey, Bougie Gang, these lifers have a lot of time to create a mess in the courts. Absolutely, Stormy. That's funny. Who asked? Bailey asked that question. Bailey, that's a everyone's pretty much, no. No one, I don't, you know what I'm saying? Like, girl, I'm not let me just start this back up and be quiet and be quiet.
No, Waukesha had Nexus Lexus, or however you say it, Lexus Nexus, or
Oh,
which is
they're very similar. If you figured out Lexus, you can figure out Westlaw. In my humble opinion.
Judge, you're being too nice. The judge seems to be very nice. She's very attractive. Ma'am, just button it up a little bit. Like, if you're then you can figure out this. So he's got a high school diploma. So you think you're a lawyer and a judge. You're telling him maybe he can figure out. Maybe Daryl Brooks is super duper smart, but he's I would make him. I would say motion denied. Okay.
One thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law uh, together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. Mr. Attorney Basie, is there anything the state wants me to consider or any additional information from the state today? All right, then, as I indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a criminal conviction. And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the U.S. Supreme Court and Douglas versus California, 372 U.S. 353 from 1963. There's no dispute here today that Mr. Brooks is indigent. This court has noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waives the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4 sub C. As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Oman versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case, the Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist rights, which I've talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26th of 2024. 5. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022. I just want to, I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through like 77. The court makes some findings that I believe are confirmed here today, and that's, he said today he had a GED that may have been referenced as an HSED. I think they're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that.
She got to
efficiently
say
and
no. I
effectively.
mean, I think it's a waste of time.
He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And so I'm just going to rely and incorporate herein by reference many of the findings or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise, that he's intelligent, he understands the dangers and disadvantages of proceeding on his own. He's made the request. He now knows that.
This is just going to solidify, sir, you're spending the rest of your life in jail, which is, I mean, that's what it's going to be, right? But at the end of the day, you, sir, is solidifying you're not getting out. So maybe that's just what he wants.
SPD's position. He indicated it doesn't change his mind. We've discussed many of the disadvantages and potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Covey to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so again freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Covey's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Covey, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Covey?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials, that I can file a letter with the court saying that we have done so, make a record of that, and then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess you can sign the order.
I mean, he's being very overly, I don't even want to say he's being overly nice. I just think he knows that this is stupid and like, don't bother me. Once you take me off, I can't help you. So I don't know. I don't know why she approved this. I think any other judge would be like, I'm sorry, you can't do it. I mean, he does meet the requirements, but the one thing I'm hearing that they did not do, she didn't contact, which maybe she doesn't have to contact the facility where he is to make sure. Because just like with Sarah Boone, they had someone there from the prison to find out, can you take the banker's boxes? Okay, no. Okay, he's gonna have jump drives. Is he gonna have access to a computer type thing? Like, that's gonna be a problem.
At any time, I don't, and
But if he's
oftentimes
not getting out anyway, I guess it doesn't
on the
matter.
e-filing system, even after I've been withdrawn, it's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out.
My
Not
clerk-
trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast, and we want to make sure everyone gets there
Thank you.
till the end. Thank
Thank
you,
you, Judge.
everyone. Good luck to you, Mr. Brooks.
Thank you.
Good luck, sir.
They said someone said that he may have gotten his teeth knocked out. I'm not sure. Let me get a screenshot so I can get this for my. Let me get. Oh man, it cut his name off. Let me do it again. I did find a little more footage from that probate hearing with Dorothy Latigue. If you guys want to watch that real quick. Let me see. Daryl Brooks over here wasting people's time again. Okay, let me see. Do I still have it up? Excuse me, guys. Let's see. So someone did ask about Darnell Jones, Kimani Latigue's dad, and if you weren't here earlier, he has been released from the hospital and he is in jail. Okay, let's see what's going on here. Let's flip. Share this tab. This is kind of a long report. I really just want to go and see what's going on with Dorothy over there at the jail. Let's watch this part and then I'm gonna let you know.
April 11th, her grandmother, Dorothy Latigue, said in court that her family is
So the funeral is going to be Friday, and that's going to be the private situation. That's going to be the private
community and children's services in response to Keimani's death.
Now, we learned just today there will be a public funeral for Keimani on Friday, April 11th. Her grandmother, Dorothy Latigue, said in court that her family is working with Dale Riggs Funeral Home. Dorothy argued in court today that the original plan was to have a private and public funeral last week.
However, she says the holdup came when Keimani's mother, Tiara Caston, wanted to have the right to Keimani's funeral planning and estate. Tiara claims Dorothy was trying to block her from attending the funeral. Ultimately, the judge granted Dorothy the right to proceed.
And how long was your granddaughter living with you on a daily basis? For 5 years?
For the past 5.5 years, yes.
How frequently did your daughter visit?
We haven't seen her collectively since her 11th birthday, which was 2022. And my other daughter went to Cleveland to pick her up. Other than that, she claimed she had no transportation to even come to the birthday party.
So I'm sorry, you might have said this already. There would be a private funeral?
There will be a private ceremony and then there will be a public ceremony for all of those that donated. It's our way of saying thank you. We appreciate, your gestures.
When would the private one be?
The private ceremony will be for family only.
That would be when?
That will be Thursday.
And then the public ceremony, right?
Correct.
That's, and the funeral home is, can you do that?
Yes. They're just waiting on me to get back in contact with them and let them know whether we should go forth or, you know, if it rules in her favor, what she's going to do.
I have not resided in Toledo in 12 years. I left because of the strain between me and my mother. As I said before, I was
She didn't even turn her camera on. How are you coming to court to try to claim your child? And then they have information like you hadn't been there for 3 years. And on top of that, girl, you didn't even turn on the camera. Can you turn on the camera for the Zoom? But you want to be responsible for her remains after everything that happened to her? Not that Dorothy's any better, but at least she got a plan.
under the impression by other family members that have been in contact with her that I was not to be invited to my daughter's funeral procession. I have been threatened, not by my mother, but by my sister, who has been steadfast, sticking to my mother. And that's okay, I don't mind their relationship at all, but I have been threatened by my sister during this whole thing.
As in a lot of situations where family people aren't getting along really well, we hear different comments about things that aren't relevant to what we're doing here. But my focus today is on the statute and the items that the court's to consider. And the ones that stand out the most are close personal relationship, and then reasonable as the practicality of any plans the person has for disposition. And convenience of family members and other friends wishing to pay their respects to the declarant. And based upon those three factors, it's clear to the court that the application for right of disposition filed by Dorothy Latigue shall be granted. So the court will issue a entry within the next hour or so, and so we'll get that to the funeral home, and we will proceed to get this child laid to rest. And I'm not saying anybody's right here or wrong, but I'm saying based upon the factors that I need to consider, those factors weigh in favor of you having right of disposition. Basically, a lot of it's a close personal relationship, and you raised this child.
No further details have been
questions about who was and wasn't involved in Keimani's life and care. That includes those questions that center around the role of the man identified as her father, Darnell Jones. Again, he is charged with Keimani's murder. And Lucas County Children's Services addressed whether the agency had any knowledge of a paternal figure and how that could have impacted their investigation or placement decisions had he been identified.
If Dad was part, if it ever had surfaced in a conversation, or if he had come up, would that have made your work any different? Would the caseworker have handled it any differently if Dad was listed or mentioned?
Yeah, absolutely. If there's a father that's identified, we have to talk with all the principals in the case. So the identified can be two ways. One, established as the father in the case, and we have a record of that. Or the child can identify somebody that they view either as a father, an alleged father, or an actual father. So if either one of those things had happened, if our database had indicated we had an identified established father, we would have been required to reach out to that individual. If the child had identified, hey, this gentleman is dad, or he is a support, or I view him as dad, we would have reached out. those did not occur in December or March of last year.
And would that have changed what you would have done when it comes to a placement with her if dad had surfaced?
No, I suppose it depends on what we would have learned. From whoever was identified as dad. But no, I mean, we determined that the placement there was appropriate. All the basic needs of the child were being met. She was getting all of her sustenance, her housing conditions were fine, her school and medical conditions were being met. So the presence of a father would not have caused us, I think, to recommend to the juvenile court that they change custody or placement.
Leadership from Lucas County Children's Services is pledging change and compassion. Suzette Cowell.
Yeah, they did a press conference. Yeah, this is the press conference, like a 40-minute press conference, and answered some questions.
And we take very good care
I think
of
they
Her store team.
okay, but that's the main news for today, is that Darnell Jones is in the custody of Columbus, and he'll be eventually extradited back down to Lucas County. And Granny Dorothy got the rights to handle the funeral arrangements, and the funeral, she said here Thursday, but I think it's actually now Friday, the private family funeral. And I guess there's going to be a public funeral following for the community at large, for people who want to pay their respects to Kimani. So yeah, y'all, a lot going on. You know, yeah, we haven't even gotten to like the legal phase yet, as far as him going to jail and the case and all of that. But as far as what happened to her, we don't even know what happened to Naziah. It could be, we don't even know. Either way, it's horrible. So yeah, right now, what we don't know, this is coming together, and it's coming together, and their child's getting laid to rest and all of it. But I mean, it's still horrible. Is this the grandmother giving interviews? Baby, yes. Ma'am, Miss Dorothy, yes. The one, yeah. She's been on every news program. And then the daughter, Kimani's mother, who's trying to fight for the opportunity to handle her funeral arrangements, she's over there on Zoom and doesn't even turn on the camera. Are you kidding me? Not that that makes a huge difference, but you are in court for your daughter, for the right and the privilege to handle your daughter's final arrangements. And you've got your actual mother saying you haven't been around for 3 years. It's just not a good look, sis. So anyway, but she tried. Tiara tried it, and Dorothy is getting the right. We don't know what happened with Dorothy. I know a lot of people say Dorothy needs charges. I guess we're gonna see how that pans out. Anyway, guys, let's see what you guys are saying. Are you talking about Naziah, or who are you talking about? There's so many. There's just been a never-ending amount of children who have been in these awful situations. I'm good. I'm glad social media has highlighted these cases. Unfortunately, this type of thing is happening. It's happening everywhere. It's awful. If you're talking about Naziah, yeah, I didn't say that. I'm just trying to find some words to put together for this is happening. Seems to be a better situation. I don't know. Naziah's body has not been located. There is no body. And according to the prosecutors, I think what they told the family is to not expect to find one. So we don't really know which one is worse, you know. It's hard to compare because all these situations are horrible. Anyway, guys, I'm gonna let you guys go. I'm gonna come back later. I will come back later, but yeah, this is what we got going on right now. The judge grants the rights to Kimani Latigue's grandmother to go ahead and finalize funeral arrangements for Keimani, and that was settled in the probate court. And I guess we'll have to wait to hear about the arrangements and the final arrangements through the funeral home. We'll put all of that information out. Dorothy has been doing lots of interviews. We don't really know what her situation is. She just seems so angry, right? And I just want to thank all of you guys. I do see some of you guys have rejoined, renewed, upgraded, all of that kind of stuff, your memberships. It is so very much appreciated. I love you guys. All of my new members, everybody. I appreciate y'all. You know what? Okay, I will put something up on members in a little bit. So I don't want to say too much, but members, I will see you later, and all of Bougie Gang, I will see you guys later too. Okay. You guys take care. Have a good one. And we will talk again a little bit later on this afternoon. Okay. All right. Bye guys. See you later.